Hi, folks. I'm Mike Klarman. I teach constitutional law, constitutional history at Harvard Law School. I'm going to tell you some things that you may not have known about the U.S. Constitution, things that may surprise you. You can learn more about these cases in our online course, Equality, Race, and Constitutional History. Number one, Brown versus Board of Education, where the court struck down racial segregation in public education. It seems like an easy case. The justices were unanimous. Well, it turns out it was actually a very hard case for them. They were deeply conflicted over whether to strike down segregation. School segregation seemed to them and to us obviously indefensible as a moral issue, but the justices weren't sure that the traditional legal sources of constitutional interpretation, things like the text of the 14th Amendment, the original understanding of those who wrote the amendment, judicial precedent, history and tradition, suggested that racial segregation was unconstitutional. So what do you do when something seems obviously morally indefensible, but you're a judge who's supposed to stick to the legal sources? That's why Brown was such a conundrum for them. Number two, the United States Constitution never uses the word slave or slavery, but in several provisions, it's clear that they were protecting the institution of slavery. Southern states get more representation in Congress because of their slave population. That's the infamous 3/5 clause. The Constitution protects the foreign slave trade for a generation so that Southern states can import more slaves. The Constitution has a fugitive slave clause, although it doesn't use the word slave, which entitles Southern owners to the recapture of their slaves if they flee to freedom. Why wouldn't they use the word slavery? It's almost as if they were a little embarrassed by it, but at the same time, they made clear compromises with the institution because they couldn't have accomplished a union with Southern states that were so dependent on slavery. Number three, one of the most famous or infamous Supreme Court decisions of all time is Dred Scott versus Sanford in 1857. The court there weighed in on the most pressing political issue in the country, which was the fate of slavery in federal territories. Congress had prohibited slavery back in the Missouri Compromise in 1820 in the Louisiana Purchase territory bought from Emperor Napoleon. The Supreme Court said that was unconstitutional. Now, what the court thought it was doing was rescuing the country by taking this incredibly disruptive and provocative issue off the table. But that's not what happened. In fact, Dred Scott proved so provocative to Northerners that they radicalized and started to adopt positions that ultimately drove Southerners to secession and then Civil War. So we see the Dred Scott decision as an infamous decision, but the justices who decided it clearly thought they were saving the nation, even though ironically, they probably advanced the nation down the road toward civil war.